And so I was, let's say, tasked to analyze some systems in the world which are basically identifying the hidden assets of not only political officials, but public officials, but also some other individuals, and how this is then used against them. And I have to explain from the beginning why is it important that we confiscate the illegally acquired property. You know, the bad guys in the area of organized crime or corruption, they take going to jail as a professional risk. They go to jail easily because they know if I come out, there'll be still millions waiting for me. If you take these millions away, if you confiscate these millions, they lose the essence of their existence. There's nothing more for them to work for. And we had cases in the past where criminal organized groups simply ceased to exist when the assets were confiscated from them. So that's why this is important. So let's say I took a look at some countries, and let's say I had the pleasure 10 days ago to be present at a similar conference in Sarajevo, and we are discussing this topic. And there were representatives from Lithuania, from the Special Investigation Service, which is their specialized anti-corruption agency. And basically, what they are doing is they're splitting their activities into different parts. First is the asset tracing, which means that they are running through 284 information systems and 95 registers to collect information on the assets of their public officials. And they're looking for assets, they're looking for income and expenditure, and they're looking for transactions. They even have a special analytical tool in doing this. The only problem which I see is that they can only do this when there is a suspicion of a criminal offense. You will see later on why I think this is a problem. And if they find the, let's say, unexplained wealth, as they call it, they start the asset investigation, and then the whole process can end in 3 different ways. First, this is a criminal confiscation. This is the typical confiscation which comes when somebody is sentenced for criminal offense. Civil forfeiture, confiscatio in rem, as the Latin used to say, which means the courts do not have to prove that these assets derive from a very precisely defined criminal offense, but there is a balance of probabilities that the assets which somebody has still were acquired illegally. And then they have a criminal offense of illicit enrichment, following the relevant provision of the United Nations Convention Against Corruption, basically having assets which you cannot explain legally. This is criminal offense in Lithuania. Next one, it might come as a surprise for you, it's Bosnia and Herzegovina. Bosnia and Herzegovina is an extremely difficult situation when it comes to fighting corruption. However, they have an anti-corruption unit in the canton of Sarajevo, which is basically applying exactly the same principle as the college in Lithuania, with one difference. In Sarajevo, in Canton Sarajevo, it is this anti-corruption unit which is basically developing and establishing databases which they use for searching for assets. Let's say in the case of Lithuania, it is the state, it's the government deciding which asset, which databases will be there. In case of Canton Sarajevo, it is the anti-corruption unit. And then all other institutions have to feed the information into the system. Well, needless to say that this Canton Sarajevo is unique in Bosnia and Herzegovina, and it is now being used as an example not to follow in Bosnia, because they are so effective that politicians in other cantons simply got afraid of it, and they simply do not want to follow the same example. When I was in Bosnia, I had the pleasure to listen to the very attractive presentation of General Salerno. You will hear to it. I hope you will have approximately attractive like the one in Sarajevo. So basically, they do things. I don't want to steal the presentation, but what Guardia Finanza is doing, basically, they have developed their own system. It's called Molecular, which is automatically comparing the information about the assets based on all available databases. And at the end of the day, this system is basically automatically accounting the difference between the legal assets and all other incomes and expenses. I hope I got it right. So this is really, really an important feature, and more you will hear from General. UK, there'll be experts from UK today. Basically, they're applying with some varieties. Again, the system of, let's say, criminal confiscation, civil order confiscation, and what they called unexplained wealth orders, which is basically a decision of the court applied against an individual who cannot reasonably explain the sources of the funds and wealth. Last one before my suggestion for Montenegro, this for sure it will surprise you a lot. Papua New Guinea. Well, I have to say, what they have is a very good law, but which exists only on the paper. What happened here is, obviously, I learned that later on, when Papua New Guinea was developing their legal framework, they were copying many laws from Australia. So they copied a law which is called Proceeds of Crime Act from the now New South Wales from Australia. But when they were copying it, they made a mistake. You know, they missed a word when they were copying it. And usually when you miss something, when you do the copying, things turned out to be bad. In this case, things turned to be very good. So the law which they have now is much better than the original. The only problem is they don't apply it. But still, they have a very good law. So what is the law saying? The law is simply saying the following. Their anti-corruption agency and their prosecution service can ask the court to use something which is called unexplained wealth order if they find out A, that individual has engaged in serious criminal offense, B, that there is a possibility that somebody has been engaged in a criminal activity without the need to specify which criminal activity, and C, if any of the public officials' current or previous wealth was acquired unlawfully, whereby the officials have to prove the lawful origin of their wealth. Which means that their specialized anti-corruption agency and their prosecution service can go to the court and tell them, listen, A, this person has acquired illegal wealth from the criminal offense specified. B, there's a reasonable suspicion that somebody might be involved in some criminal activity. And C, this guy is very rich, but they don't know, he or she doesn't know how to explain what is the origin of the assets. And then, of course, the court orders this individual to pay the wealth, the value of the unexplained wealth. It is the court decision. So let's say, what I think would be the best for Montenegro? Three options, of course. The first, traditional criminal confiscation. The level of proof here is beyond a reasonable doubt. The second one is the civil confiscation, which I think it could be started by public prosecution, decided by the court on the balance of probabilities. You see, the level of proof is much lower here, because balance of probabilities is much lower level of proof than beyond reasonable doubt. And, of course, applying the reverse burden of proof. And, of course, for that, a special law is needed. We had it in Slovenia, but let's say the authors of our law, they made it a mistake because they wanted to apply it retroactively. And, of course, the law was simply squashed by the Constitutional Court. So we have a new one. It's not functioning well, but hopefully this will happen once. And then the next one, I would say that also your, let's say, anti-corruption agency would have to have the opportunity to go after the unexplained wealth, which means that the ISK would have to be connected to all relevant databases and collect information about assets, incomes, transactions, comparing it with report assets, and then when they would find a huge difference, or let's say important difference, to report this either to the prosecution service to start the investigation for unexplained wealth or civil confiscation, or to the IRS, revenue services. No, because in some countries, including mine, the system of this civil confiscation doesn't work fine. But if in Slovenia you're in possession of assets where you cannot prove that you have acquired those assets legally, you pay 90% on the taxes on this unexplained wealth. So there are models which are out there already. I know that Montenegro is really trying to get something here, and I think this would be really important, you know, especially because Montenegro is a very small country, and we see people who are having a lot in this country stitched out, and many of them are believed to collect all these of their assets legally. So as long as citizens of Montenegro would not see these guys not only going to jail, but also being deprived of the illegally acquired proceeds, their level of trust in institutions will be very low. Having this in place, functioning in practical life would be for sure a very important element of bringing Montenegro towards the European Union. And I'm sorry for being long, but I had to do the comparisons.